And welcome to the week 11, chapter 11 video lecture. In chapter 11, we're going to go into disclosing and suppressing evidence. We will see that in the criminal world, this is often the fight, and maybe the one and the only fight in the action, because if the evidence is going to be allowed on, it's pretty conclusive as to who did what and when and under what circumstances. So the fight then becomes whether the defense can suppress available evidence that the prosecution has enough to be able to do away with the case. All right, so that's the issue, as we'll see. Now, also, we're going to get into issues of prosecutorial disclosing of evidence to the defense, and also the reciprocal discovery where the defense has to do the same for the prosecution. We'll get into all that, okay? All right, so let's get right into it, and let's see what we're going to learn. First, we're going to explain the reasons why the process of discovery exists in both civil and criminal cases, but is significantly curtailed in criminal cases. It is, in fact. It's often difficult to get criminal discovery like you can in a civil case. In a civil case, you can get everything except privileged materials, including all documents, testimony from every single person involved in the case, or either on one party's side or the other, or anywhere, any third party. Essentially, it's pretty much unlimited, except for privileged matter. And in criminal cases, there isn't much discovery. Witnesses don't have to speak to the defense attorney. What they say, at least some part of it, is in the report, but often not all of it. And sometimes there are surprises because maybe the police didn't ask the right question, didn't get the right information. But it's not there for the defense, it's not disclosed to the defense. And all of a sudden they find out at trial, this witness has more to say. And it's very difficult for them to deal with that because they don't know what to do at the time of trial. They can't go out and try to find witnesses to see if that person is lying or not. A little too late. Anyway, so we'll see that in criminal cases, the amount of discovery is much less than it is in civil cases, and we'll go into some of the reasons why. Next, we're going to differentiate formal versus informal discovery and the reasons why both are used in criminal cases. And then we're going to identify the types of evidence subject to mandatory criminal discovery. That means where the prosecutor must disclose it to the defense. We're also going to compare and contrast the exclusionary rule and the fruits of the poisonous tree doctrine, and we'll see that that's a judge-made rule to keep police honest to maintaining people's constitutional rights. And so the exclusionary rule is used as a way to take away the benefit if police end up getting evidence through some illegal means. We're also going to summarize the decision in Miranda versus Arizona that regulates the process of police interrogations of suspects. That's a very big area for litigation also. We're going to explain the requirements governing the application for search warrants, the issuance of search warrants, and the execution of search warrants. We'll see that search warrants are often given out, but they are required for residences except under very unusual circumstances. They may not be required for any other kind of searches, so long as there's probable cause to search in areas that are considered private. And so we'll see that the only place left, essentially, for all intents and purposes, in which a search warrant is absolutely required, except under very unusual circumstances, is your own home. Okay. We're also going to identify the major exceptions to the Fourth Amendment's warrant requirement, and we'll see that when you put those exceptions together, you're going to find out that pretty much your residence is the only place where a search warrant is required. Then we're going to analyze the effect of the exclusionary rule on the operations of the courtroom work group. And then we're going to evaluate the exclusionary rule, whether it should be abolished or not. It was started pretty much in the 1960s when the court was trying to find a way to prevent police from continuing their crazy ways of investigating, which used to be round up the usual suspects, get one of them to confess by beating them, and then you got yourself a conviction. That's sort of the way it was. And they had to find a way to stop that. All right, let's look at discovery. Discovery is a process, by the way, that goes on. It is done through the law. That means that it's required. In some cases, it is discretionary in others. It depends on what kind of case and exactly what needs to be discovered. But discovery means that you're giving to the opposite side information that you have, whether that be through witness statements, whether that be physical evidence, whether that be names of people who claim to have some knowledge of the case or of certain aspects of the case. Whatever the information is, if it has to do with a case, it's possible that it might be something that must be discovered, which means if requested, or in some cases, it just not even if it's requested, but it's just required, that one party will give the other party certain information, either, as I say, either after it's requested or just mandatorily required. And we'll see how that works in both civil cases and criminal cases, because civil cases, you can ask the other side, that means your opposing party, for testimony of every person within the the group that we call the opposing party. Which, if it's a corporation, it could be thousands of people. You can insist on actually deposing, making them get before a notary public and swear to tell the truth, just like they would in court, and testify to your questions. And they have to answer the questions just like they would in court. They're subpoenaed just like they would be to a court proceeding. You can request all documents the other side has, other than privileged documents. You can make them answer written questions. This is in civil cases, by the way, not criminal cases. You can get physical and mental examinations of parties to the action who are claiming physical or mental injuries. You can get you can make them admit certain facts, essentially, or suffer the consequences if they later refuse to admit certain facts in the civil case. You can't do that in criminal cases. What you can do, there's a grand jury proceeding that will allow the prosecution to find out what certain people are willing to say if they subpoenaed them to the grand jury proceeding. That's sort of a discovery process that they can go through, and certainly police can interview witnesses if they're willing to talk to the police. But in criminal cases, what is discoverable depends on the circumstances. What minimally will discover will go through in particular. But just to understand the discovery process itself is that there is certain information that both parties have, and we make them exchange a certain amount of that information. Sometimes mandatorily without even a request, and sometimes you have to request it. Depends on the local law. But if there's a constitutional duty on the part of a prosecutor to disclose certain information, then they must do so even without a request. And it is true that in our system, there is a constitutional right on the part of the defendant to receive all exculpatory or potentially exculpatory evidence that the prosecution has. All of that information, if it's exculpatory or potentially exculpatory, which means it either will it will be able to find the defendant not guilty of the charges, not just because it raises a reasonable doubt, but it actually is evidence that says the defendant did not commit the crime. So it's either actually or potentially that kind of evidence, then it must be given to the defense even without a request, and essentially immediately. Okay, makes total sense. We don't want the defense to be without that kind of information. That's the kind of information they may not have. It may make the difference in the case, certainly, without a doubt. All right, so let's look at examples of what kind of information can be required to be discovered. Lab reports, if prosecution is doing a lab analysis of certain evidence, certainly, most likely that will be required to be discovered to the defense. This is all before trial, by the way. Discovery process is what goes on before trial. Once you're in trial, there should not be anything that has not been discovered to the other side, or there's a reason for a continuance of the trial if you didn't. Statements of witnesses, certainly. Defendant's confessions, if there are any, and all the police reports. Anything written up by the police regarding this case, or in potentially even other cases if they relate to this case, must also be given over. Okay, that's typical, but we'll go into specifics of this a little bit later on. First, there's no general constitutional right to discovery in a criminal case. That's Weatherford versus Bursey and State versus Toon. There's too much prosecutorial disclosure may result in defendants taking undue advantage. In essence, what they mean here is that let's assume that the prosecutor knows that there is a defense witness out there who's willing to say, I was there at the time, I saw who shot the victim, and it wasn't the defendant that you're prosecuting. Okay, well, let's assume the prosecutor then goes out and finds 3 witnesses who say, I was with that witness at the time they say they were at the scene of the murder, and he was nowhere near the murder at the time. Okay, that's what we call rebuttal evidence or impeachment evidence. That's evidence that will tend to show that that witness is lying. Okay, that's pretty powerful stuff, and it's only powerful if the defense does not know it. And the reason why is because we hope they'll walk right into a trap of putting on false testimony, and then we will expose it, and the jury is going to see that the defendant or the defense is trying to lie to them, and it's going to be very bad on the defendant's side. But if we were required to give that kind of evidence to the defense, then they can do lots of things. They can find a way to try and get around it. They can then go look for all sorts of, in a sense, they can start preparing for it, where we don't want them preparing if we have impeachment evidence like that. We want them, if they're going to lie, let them lie right there on the stand, and then we're going to expose it. So that's what they're talking about here in State versus Tuna. Too much prosecutorial discovery may result in the defendants taking undue advantage of that discovery. So that's, in essence, there's no general right to discovery in a criminal case under the United States Constitution. But what is discoverable is exculpatory evidence, for sure, absolutely. As we'll see, if the prosecution has exculpatory evidence, that means evidence not evidence that would be helpful to the defendant to establish a reasonable doubt in the case, but evidence that by itself would establish the fact that the defendant did not commit that crime. It has to by itself be able to do that to be called exculpatory. That's powerful evidence. That definitely should be going into the defense, as you might imagine. Otherwise, why doesn't the prosecutor? I mean, the prosecutor's not going to bring it up. Only the defendant would bring that up at trial. Okay. Impeachment evidence in some states is required to be given out. I'm not in favor of that as a prosecutor. Again, for the reason I just described. Impeachment evidence is only good when you let someone come up on the stand and lie because they don't know you have that evidence that's going to impeach them, and then put it on there, and then the lie becomes very apparent and that kind of thing. So discovery of exculpatory evidence absolutely required. Brady versus Maryland back in the 1960s established that. Kyles versus Whitney as well. More recently, discovery of impeachment evidence. Again, that's not necessarily required. Now, this would be, of course, of defense witnesses, but if the prosecutor has evidence of a prior inconsistent statement or essentially impeachment evidence of the prosecution's witness, then they have to give that over. And that's the Jenks decision. Now, in Giglio, they expanded that to not only prior inconsistent statements of prosecution witnesses, but anything that would tend to impeach a prosecution witness. And that just makes sense. If there's evidence out there somewhere that tends to indicate that a prosecution witness is not telling the truth in any regard, it needs to be given over to the defense. No doubt about it. Okay, discovery rules are important to defense attorneys for a number of reasons. First, it helps them to save time. They don't have to go out necessarily and investigate and find out this information that might be available to them through the prosecutor. But more importantly, if we do it right and we have a good, solid case as a prosecution, then it actually greatly encourages guilty pleas and eases the attorney-client relationship, because now what happens is there's plenty of evidence out there. It becomes, when we discover all this very important evidence, all of a sudden now, so the jig is up. And so now the defendant will tend to be more malleable to the defense attorney, because now the defense attorney can say, there's no defense in this case. Now we have to do damage control kind of thing. So that's the law in action point of view about prosecutorial discovery. It has good effects on the system. Okay. All right, let's look at the exclusionary rule. There's been several cases here that have brought out the exclusionary rule, but it is very important that we understand each of these decisions very quickly. The Weeks decision, the Wolf decision, the Mapp versus Ohio, and Dickerson versus U.S. These are important because what they do is they tell us a little bit about how the exclusionary rule kind of came into being, because it's more than just let's say Fourth Amendment violations, illegally obtained evidence. It can be also in the area of confessions that were not voluntary because of certain activities of the police that made it not voluntary. It doesn't necessarily have to be torture, but it could be a lot of different ways that you can put somebody in a situation where they feel like they have to confess to something, even if they perhaps didn't even do it. And so that we can even exclude confessions, again, if they're not properly obtained under the exclusionary rule. So essentially, the exclusionary rule will be used in any situation where the court wants to make a statement to police that if you're going to do this stuff and violate our rules regarding what you can and cannot do under the Fourth Amendment, Fifth Amendment, and all the other constitutional rights that may be out there, we're simply going to exclude any evidence, any fruits of the illegal activities as a way to first give you an incentive not to go out and try to collect that kind of evidence, and then second, to not subject the defendant to that kind of evidence in violation of their constitutional rights. So in essence, we're not going to let you violate their constitutional rights and get away with it. If you do violate their rights, we're not going to let you use that evidence. Now, there's no constitutional requirement for the exclusionary rule. It's a rule enforced by the courts as a way of enforcing the constitutional rights of criminal defendants. By the way, there is no exclusionary rule in civil cases. So if we did find illegally obtained evidence, we can use it in a civil case. We cannot use it in a criminal case, for the most part. Okay. The exclusionary rule also prohibits the prosecutor from using illegal obtained evidence at trial. And again, that's why we often will win or lose a case in the motions, the pretrial motions, where we litigate this issue of whether there was any evidence that was illegally obtained and needs to be excluded. If we win as the prosecutor, then all of our evidence in the case is there, and we would assume that the defense would say, okay, well, we're not going to fight the issue of guilt any longer because the evidence is now considered legal, and we'll now have to deal with sentencing. All right, it's justified on three grounds. First, this is the exclusionary rule, of course. It's justified on three grounds. First, the courts should not participate in illegal conduct and allow it to be used in their court proceedings. It deters law enforcement misconduct. And other remedies like civil remedies, suing a police officer for illegally coming into your house and then finding all this evidence, they're just not workable. They don't give the person any kind of real relief of what they're dealing with. The police should never have had it in the first place. If they shouldn't have it in the first place, they shouldn't get it into the case at all. Now, the next question here is derivative evidence. That means evidence that's derived from an illegal search. Let's assume for the moment that police go into someone's house. They do not have a search warrant. It's illegal for them to have gone in the house, which often it is, without a search warrant. They find drugs, they may find drugs in the house. Let's assume they find a little stub that says that the person is renting a storage facility, and they think, I wonder if we can find some more drugs in the storage facility. So they go to the storage facility, they open it up, and they find more drugs. Well, that's derivative evidence. It was derived from the illegal search. It never would have been there had it not been for the illegal search. So it is evidence derived from an illegal search. So derivative evidence then is subject to this fruit of the poisonous tree doctrine, which says if your evidence is fruit from the illegal police activity, then that fruit, the derivative evidence, will be excluded also. So in essence, you can infect your entire investigation as a police department on a certain case by simply making one big mistake and illegally taking evidence that ends up taking you in many different directions, and you fill out this poisonous tree with evidence. It's all bad, and you didn't even know it because you didn't realize perhaps that you were doing something illegal, and now you've ruined an entire investigation. You can't use any of it. Now, poison simply means it's evidence directly obtained as a result of a constitutional violation, and fruit is derivative evidence because of the knowledge gained from the first illegal search. So, in essence, poisonous tree means it's just it's coming from a constitutional violation, and the fruit is the derivative evidence that came from the original illegal search or illegal police activity, whatever it may be. By the way, it's not limited to searches. By the way, police, if they beat somebody into a confession, that will be excluded under the exclusionary rule also. And if there's something that comes from that confession, most possibly, that will be fruit of the poisonous tree and will not be allowed in also. All right, there's several doctrines that have mitigated the sort of absolute rule of the fruit of the poisonous tree. Sometimes things happen in a certain way so that the exclusionary rule no longer acts as a deterrent against police, and when that happens, the courts will refuse to find the evidence illegal and exclude it from the trial. When essentially something's going on here that makes the evidence something that's not wrongful anymore, essentially, then we're going to allow it in. Okay, so one of those is the independent source rule, and what that means is if you were able to get to the same evidence through an independent source, that means not through the original illegal search or illegal police activity, you get to it through a secondary method that was legal, then you can have that evidence. Okay, so the problem is that if you are trying to create the independent source based on knowledge of what you already found out in the illegal search, it's probably not truly an independent source. And the reason for that is that it's not. It's what you've done is you've got a clue as to where the evidence is, what it is, and you can't go out and re-find it again without knowledge of it because you know it. So let's assume you have an illegal search of a house, and you later go back in the house with consent. Well, you sort of already know it's there, and so you're trying to get in with consent because you already know the evidence is there. So that's not independent. But let me give you an example of what would be an independent source. Let's assume that you beat someone, or not beat somebody. Let's just say you unduly influence someone into telling you where the body is of the little girl that you just killed. So you start, not exactly, you don't beat them up, but you psychologically psych them out by saying that the family needs closure. We know you killed her, but we need to find the body so the family can have closure. You make them feel really, really bad, and you hammer them for hours and hours and hours and hours. Doing all that is going to, that's softening up kind of process. That's going to make the confession illegal, no doubt about it. But let's assume also that you had, some explorer scouts out looking in all these different directions, and they were going to cover a certain amount of territory. But before they do, you get the person to confess. They tell you where the body is. You go find the body, and the finding of the body is illegal. It's fruit of the poisonous tree. It's fruit of the poisonous confession. That's illegal. Okay, but if you can show that your explorer scouts were going to go by the same area and would inevitably have discovered it, then it's coming from an independent source. Now, that's also very much similar to the inevitable discovery rule too, but the independent source, it's just an independent source. We in fact did find it or would have found it, and or you just go through your investigation normally, even after you've done something illegal. You have other sources of information that end up finding the same stuff, then it's an independent source. The independent source, so long as it is legal, will make the finding of that evidence now legal because you found it through a legal mechanism. There's also an attenuation doctrine, and what that says is sometimes the taint of the illegal activity has now attenuated so far that we're not going to connect the two any longer. And that can happen typically when a good example of that would be you have an illegal confession, and they tell you about certain other people who were there at the scene when the crime was committed, and then you go out and talk to those other witnesses and you get all that evidence. That's probably sufficiently attenuated. The finding of the witnesses themselves and what they have to say is sufficiently attenuated from the now illegal confession to allow the evidence of the witnesses themselves to come in. Otherwise, they would be fruit of the poisonous tree. Now, inevitable discovery is very similar to the one I just went over for independent source, and that's where if you can show that you would have discovered the information anyway as part of your investigation. It was already underway. There were several aspects of the investigation, and they would have come upon the evidence anyway. Then you allow in the fruit of the poisonous, what would otherwise be fruit of the poisonous tree. And so the question is, how can you prove inevitable discovery? You have to show what your investigation was doing and the different paths it was taking, and then show that these two paths would have come together and found the same evidence. Okay, so it all depends on the circumstances, but if you could prove that you would have inevitably discovered it anyway, you just happen to have discovered it early because of the illegal source, then you get the evidence as a prosecutor. Okay. Next is good faith. Now, I'm going to give you an example of the good faith. The good faith is what they're going to say here is they're going to say, well, the police officer did everything possible to make sure that he or she was doing things legally, and we as the courts later found that what he was doing was illegal. But boy, this police officer did everything possible to make sure that they were legal in whatever they did. Well, we're not going to find that evidence is illegal. We're going to let it on. I mean, it may still be illegal evidence, but we're going to leave it on. We're going to let it in because if you have officers who are doing the best possible thing they can do, and they've exhausted every resource to make sure that they are doing everything legal, then the exclusionary rule no longer has any effect. It's no longer of any use. You're not properly deterring police officers because you don't want to deter them from doing everything they can to make sure that they do things legally. And so if it does not have a purpose any longer, the courts are not going to use the exclusionary rule. Let me give you an example. Let's assume you have a drug dealer in a house, and you want to get in the house. You got to get a search warrant. So you fill out an affidavit. You ask for a search warrant, and not just ask for the search warrant and go to the magistrate and see if you can't get it, but you say, I'm not so sure for sure that I have probable cause here. So let me go take this over to a trained legal person like the prosecutor, who is a lawyer and has been in much experience in dealing with probable cause and what is probable cause and what is not. And then you ask the prosecutor, what do you think? Do you think I have probable cause? The prosecutor says, oh yes, I've looked at this and this is probable cause to me. Okay. Well, then a magistrate agrees and says, yes, I think it's probable cause. Now later on, it could be that another court on a suppression motion will find that there was not probable cause for the warrant and exclude the evidence. If that happens, then the prosecution can plead good faith of the officer as a way of preventing the exclusionary rule from being used for what now has been determined as illegal evidence. Okay, see how that is? How can we expect police to know when a ruling of a magistrate on probable cause that issues the warrant is going to be overturned? And especially when you go to the prosecutor and that the best person you can think of to give you their opinion, and they say, yeah, you've got a good warrant. That's good faith. Okay, that's good faith. All right, let's look at interrogations and confessions. Very important to the courts, based on what was going on in the 1960s and before, the typical way that police were investigating cases, which is round up the usual suspects, force one of them to confess, and then you've got your case. That's essentially how they were investigating cases. All right. So the voluntariness of the responses from the person who is now the suspect become very important to the court, and they have since Miranda. And Miranda versus Arizona is a very famous case, as you know. We call the warnings that have to be given when we have someone in police custody and being interrogated, the Miranda warnings. Okay, it's based on the Sixth Amendment right to counsel, and also on possibly on the right against self-incrimination as well. But in reality, it's mostly Sixth Amendment. Through the 14th Amendment, it's binding on the states. And so let's take a look at this voluntariness standard. If you want to make sure that people who are in police custody are going to be giving you voluntary statements and they're not being improperly, more or less forced, although to force would be almost like you put a gun to their head or something. But you can force people in many different ways. You can say things like, if you don't confess to this crime, since we know you did it, we're going to take your daughter in and we're going to prosecute her too. And she's going to go away for 25 years to life, okay? That kind of stuff going on. You can have them, you can interrogate them for 15 hours with no water, no bathroom breaks. You can make it really hard on them. That kind of thing would make anybody finally at some point want to confess, just so they get away from all the pain and the suffering, even though you're not actually physically torturing them in the true sense of the word. And so what the court did is they said, you know what, we're going to make up a standard here. By the way, the Miranda warnings that we all know what those are, is not required by the Constitution. It's made up by the courts as a way to get the police to only take voluntary confessions and only take statements from people in their custody when it is voluntary. And so they make them give the warnings to the person. They warn the person. You have a right against self-incrimination. You have a right to an attorney. No questions will be asked. If you ask for an attorney, no questions will be asked until you're given an attorney. If you can't afford one, we'll give you one. And so the question is, after having heard all those things, do you want to talk to us? And so it's entirely up to them. You've made it very abundantly clear to this person that it's up to them whether they talk to police or not. And when you do that, it helps to take away from this very, very bad psychological situation that they're in. They're a suspect. They're now in police custody. That means they've been arrested. That means that they know the police at least have probable cause and maybe more evidence on them, suggesting that they committed a crime. That's a very stressful event by itself for anybody, even a career criminal. They do not like being in that position. People who have never been accused of a crime are in really stressful situation when that happens, to say the least. So the courts then decided you cannot use the results of an in-custody interrogation of a suspect unless you have given them the Miranda warnings first. And after that, the person has agreed to speak with you. If they ask for an attorney or they say they don't want to talk, you have to scrupulously honor that request. Okay? And so that's the way the courts used the Miranda warnings, this mechanism, to safeguard people who were suspects and arrested by police. Now, Miranda does not apply when the person is not under arrest. If they are simply detained, that means they were detained because the cops had reasonable suspicion they committed a crime and the cops are investigating for some reasonable period of time. The person is not subjected to the traditional custody things. They're not even allowed to be transported to the station. They're not allowed to be put into handcuffs, because once you put them in handcuffs, then you have at least a constructive arrest for all intents and purposes, and that will bring in Miranda warnings as necessary. And so you have to, it just has to be you stop the person, you're just talking to them, but you haven't brought them to the station, you haven't put them in any kind of custody yet. They're not free to leave, but they're not in any kind of custody, except that they're not free to leave. Okay. And so now what's happened is we have this standard. If it's an in-custody interrogation, then Miranda warnings must be there, or you cannot use the statements that are stated by the suspect after you've started interrogating them. Okay, so we've got to be very careful what we're doing as police officers to make sure that we either, if once we have an arrest or a constructive arrest, that we give them Miranda warnings. Okay. Now, Miranda had an extensive criminal history. He was interrogated by police and told he failed the interrogation, meaning that they had information on him that he was doing the things he said he wasn't doing. He then signed a confession admitting his guilt. He was found guilty by the jury, as would be absolutely standard. He was not advised of his constitutional rights during interrogation, and the Warren court stated his rights were violated. And this changed the way police handled interrogations ever since, because once they put in the exclusionary rule for interrogation results of interrogation under police custody without Miranda warnings, then the police had to change their tactics entirely. Well, let's consider the thinking point on the BTK killer. Excuse me. He was a mass murderer. And he admitted all of his crimes without being read as Miranda rights. Would this be admissible in court if he did? If he was a mass murderer and you sort of, got the, you talk to this guy, you go out and you arrest him, of course. You got lots of evidence that he's a mass murderer. Maybe you're even digging up bodies in his house as you're talking to him. You forget to give him the Miranda rights. Now, can we admit his confessions? No, we can't. If he's in custody, no. If it's a detention, yes, but if you find dead bodies around somebody's house, they're under arrest, even if you haven't got cuffs on them. So under what conditions would you choose not to read Miranda to this BTK killer? And do you believe this must be done to obtain a confession? In essence, or do you believe that we shouldn't give them Miranda warnings because it'll shut them up, so to speak? Well, as of right now, it doesn't make too much difference, because if you don't give them Miranda warnings and they are either in actual or constructive custody, you will not get their statements into court. As a your prosecution will not be allowed to get them into court. But these are difficult cases. These are people who would be obviously guilty, as obvious as you can get, with finding the dead bodies all around their house. They're talking to you, and maybe they're confessing to the crime, but you just didn't give Miranda. Well, too bad. Not going to happen. All right, the Fourth Amendment. Basically, if you can think of the Fourth Amendment as there will be no unreasonable searches and seizures, you've got pretty much what you need to know. It says also, of course, that you can't go into someone's house without a warrant, but what you need to know is that it's the court that sets up the standard for reasonableness on a case-by-case basis. Okay, so if you want to know whether in a certain situation, whether the police have acted appropriately under the Fourth Amendment and did a search or seizure legally under the Fourth Amendment, you'll have to go to cases like it that have already been decided by the courts to decide that issue. Okay. So what has happened over the years that the courts have been litigating these Fourth Amendment cases is they've come up with a number of decisions on what police can do and what they cannot do. And they created what we call bright line rules for police officers so that they have a pretty good idea of what they can do and what they can't do just by applying a very simple rule. They don't require police officers to be lawyers and sit down and do some really sophisticated legal analysis before they decide what to do out in the field when things are going on so quickly. And so one of the things that they decided on, and this is back in the 60s also, in the Terry versus Ohio, was that the police do have a right to stop and possibly frisk suspects if they have what is called reasonable suspicion, which is less than probable cause. That is also called articulable suspicion, that the person is or is about to be involved in some criminal activity. Okay, so let me give you an example Let's assume that you're a police officer and you're driving through residential streets at 2 in the morning, doing your normal rounds, and you notice two guys jumping over the fence from the inside of a person's backyard onto the sidewalk and then running away from you. This is 2 a.m., remember, okay, in your residential area. First thing a cop's going to think is those are two burglars who either were in the process of burglarizing and saw me coming up and are now running away, or they had already done their burglary and were surprised when they jumped the fence and saw me. Either way, that is sufficient reasonable suspicion to stop them and do some sort of initial investigation that does not require that you arrest them. Okay, so they would not be under arrest, they're just detained. Stop. You can order them to stop. If they don't, you can go up and grab them. And if they try to run, then you got them for a real crime, which is resisting an officer, which is a misdemeanor. So now you've got a real crime. And now you can arrest them. But if they stop, then you have another issue that comes up, and that is if you've got a criminal like that, a burglar. Burglars will often have weapons with them. And if you have articulable suspicion or reasonable suspicion as an officer that the person may have a weapon on them, then you can frisk them, which is simply patting down their outer clothing to see if they have a weapon on them. It's a very limited search, and it's also a very limited stop. The detention is not an arrest. It's only allowed for a limited time to do an investigation, whatever is justified under the circumstances. And the frisk is very limited also because you don't actually look in the pockets, you just feel to see if there might be a weapon there. Now this is a landmark case. So let's think about this. You think it's a good idea that we let police officers stop people without probable cause to believe they committed a crime? Is that justified? Well, in the situation I mentioned, sounds like it is. I mean, otherwise we have to let these people go. And there's really good suspicion there that these are a couple burglars, and and if they're not, a couple minutes of a detention where we're able to determine what they're doing there and why they're jumping the fence would be not very much to take away from them. You know what I'm saying? So my position has always been is that's always very justified because we don't take away very much from the citizen, but we could end up having a burglar. This often happens when there's a robbery, let's say, and there's a description of the vehicle. And some of you, by the way, in the audience, the students, may actually have had this happen to you, where you get stopped by a police officer. You wonder why, because you weren't speeding. And they say, well, I'm sorry, I'm going to have to detain you for a little while because a vehicle of your description was called in as the description of a vehicle in a robbery very near here, and so I'm stopping you just to make sure whether you are or not the robber. Okay, and what they'll do is they'll very quickly bring the victim of the robbery in a patrol car up to your car and have them look at you and see if you're the guy. And if you're not the guy, they let you go immediately. So it's a few minutes, it could be 10 or 15 minutes that you might have to stay there. And in order to get a hold of a robber, it's probably justified. But think about this yourself and see what you think. What do you think of it as a citizen? Is it too much taking of your freedom for a very limited time? Is that too much under circumstances of reasonable suspicion? Yeah, think about that. Anyway, now let's look at search warrants. Again, search warrants are required for homes for sure. We'll see later that they are not required for very much else. If the officers have probable cause to believe that there's evidence of a crime where they are searching. But first, you have to apply for a search warrant. You don't just get a search warrant. You just don't say, oh, here's a search warrant, judge, please sign it. No. You have to first go to a judge, and it has to be a neutral judge, obviously not one these are not police judges, these are neutral judges. You will sign an affidavit that truthfully and completely gives the information you have as part of your investigation that would justify a search warrant. And in order to justify a search warrant, there has to be probable cause to believe there is evidence of generally a felony in the place that you want to search. And then if you are able to convince the judge with your affidavit and all the information you have in that affidavit that you do have probable cause to believe there is evidence of a felony within the place you want to search, then there'll be a search warrant issued. And then you can now take that search warrant and go into the place involuntarily. You can break the door down if you have to, and go in and search. Okay. There's several requirements, though, in order to get that warrant. One is the requirement of particularity. First, you have to support the issuance of the warrant by an affidavit under oath, asserting enough facts and circumstances constituting probable cause to believe there is evidence of a felony in the place you want to search. You also have to specifically describe the place to be searched and the people or things to be seized if there's anything to be seized. And sometimes, by the way, your search warrant might be to go into a house because you think somebody's in that house that you already have a probable cause to arrest. And you can't go into the house if he won't let you in voluntarily without a search warrant. So you may actually be doing a search warrant in order to arrest somebody. That can be, so it's not just things that you might be looking for. You might be actually looking for people. Now, when you execute the search warrant, you first have to be executed in a timely manner because the search warrants typically don't go for more than a very limited time. Let's say 10 days to 14 days, about as long as they're allowed, typically in most state statutes. They're limited to achieving the objective of the warrant, which means once you have achieved the objective, you found what it is you're looking for, then any further searching is not allowed. Normally, it has to be served at a reasonable time of day unless you can show the judge why you must come in at an unreasonable time, such as the nighttime. We don't like nighttime search warrants. The reason why is because the Brits used to do that to us before we were the United States, and we highly resented it. They would break into your house at midnight, roust you out, and you sort of didn't have any way of protecting yourself. And it was very dangerous to both sides. And so we took that requirement and we said, no, it has to be a reasonable time of day unless there's a very good reason why we can go in at a different time. You're also required to knock and announce. That means you have to knock and tell the person on the inside, you are police, we have a search warrant, open the door. And if they don't come within a reasonable time, then you can break the door down. There are certain no-knock exceptions when to knock on the place would simply give them the opportunity to destroy the evidence. If there's reasons behind that and you articulate those well through a good investigation, you can get the no-knock exception for the warrant so that you don't have to knock first. You just break the door down and go in and get it. Performance of the search warrant must be reasonable. That means you have to go in under circumstances that are reasonable. Lots of problems come up. You go into somebody's house, there may be all sorts of people that have nothing to do with the case. What do you do with those people? Well, you're going to detain them for a period of time because you don't know who's who and you don't know what's going on. You have to detain them, and you probably will be handcuffing them because they're a potential danger to you as officers. Then you have to decide what you're going to do with them, but it's all got to be reasonable. Also, a reasonable amount of force can be used when searching as necessary. Some of the cases where this has sort of gone over the deep end is when there have been places, drug houses that are fortified so that you can't easily break in, and they have to sometimes break in with a tank. That was big in the 1980s, 1990s in LA, for instance, in Los Angeles. They were breaking into drug houses with tanks because they couldn't get in any other way. Okay. Now, after the search warrants are executed, then you have to maintain the evidence. You have to inventory the evidence, and then give the inventory over to the court so they know what has been taken under the warrant. Now, let's look at warrant exceptions because normally under the Fourth Amendment, any non-search warrant type searches would be considered illegal. But the courts have found exceptions to the warrant requirement. And mostly because things have changed since the time that the Constitution was written. For instance, they didn't have motor vehicles back then, and we have motor vehicles now. That if you don't, search them immediately, they're going to be gone. You'll never see them again, and the evidence will be long gone. But Katz versus U.S. started this process of deciding on what was an exception to the warrant. And we're going to see that when we got through with the process, the only thing that is required for a warrant now is for your residence. All right, first, there's three forms of warrantless searches. First, a consent search. If they just simply allow you to come in, you go to knock on the door. Hey, can I come in and search? They say, sure, come on in. Perfectly okay. That's one form of warrantless search. Next is plain view. Now let's assume you knock on the door and you say, can I search? No, you can't search. But while you're looking at the person, you're looking over their shoulder and you see someone at the kitchen table bagging up a bunch of drugs. Well, it's in plain view. It's in a place where you're allowed to be. You're allowed to come and knock on somebody's front door. If you know, a citizen can come to your front door and knock on it, so can the police without having a warrant, because they're not doing anything that is where it's in an area of privacy. But if they happen to see it in plain view, the search is not illegal, and if they can seize it if they have probable cause to believe that what they're seeing is evidence of a crime. Also, you can search the person who you have put under a lawful arrest. So you arrest somebody, you can search their person entirely. And the reason for that has more to do with the fact that you're going to be bringing them to a secure jail facility, and that you do not want people bringing things in there that would be contraband or dangerous. And so you're allowed to search for that reason. So these are exceptions that have been so far okayed by the courts. You do not need a warrant to get in someone's pockets when you've arrested them. You can go in and get them anyway. Now, there was no actual constitutional question on the issue of electronic surveillance. That means things like eavesdropping, you know, getting people's information through their emails, telephone conversations, all this sort of stuff. But the Omnibus Crime Control and Safe Streets Acts of 1968 did control electronic surveillance. So eavesdropping, which is just listening to people with some mechanical, or electronic device, such as putting a bug in their house where you can hear what they're saying, putting TV cameras in someone's house, bugging their phone, tapping into their emails, all this sort of stuff, became regulated by Congress with these acts, including the Stored Communications Act, which protects email. Video surveillance is allowed, of course, if the surveillance is from a place where the police are allowed to be, and can even be augmented through, binoculars and that sort of thing. And then, of course, the Foreign Intelligence Surveillance Act allows an additional amount of kind of surveillance of foreign people who are not citizens of the United States and people who are involved in possible espionage and so on. So these are areas where you do not need a warrant to get in, and for quite a bit of that, although in some of it does require a warrant. Like your telephone, bugging your telephone does require a warrant. All right, so let's assume now that we get, by the way, we can't go through every little aspect of search and seizure law and all the different exclusionary rules and so on. So we're sort of treating that as, it's no unreasonable searches or seizures, but we're just going to have to leave it to another course to actually figure out some of the most common of the rules that have been created by the courts, because that's a subject unto itself. There are experts who spend their whole life just trying to figure out where all the search and seizure law is. There's so much of it. And so we're not going to go through all of it. We just got a bit of a smattering of it. But let's go over how the process works. Let's assume that the defense thinks that there's been some illegally obtained evidence, whether it be through a search or through involuntary confession or whatever it may be. How do they make sure that it doesn't get to the trial? Well, they file what's called a pretrial motion. That means a motion before the trial. And a motion is simply a request for an order by a court. So in essence, you request that the court order something. That's what you do when you file a motion. Pretrial means a discourse that's before the trial. And it would be a suppression motion. You're asking the court to suppress certain evidence. The defense attorney will usually bear the burden of proof to prove that the evidence is illegal. And you sometimes get swearing matches between what defense evidence is put on about whether it was illegal and what the police put on about whether it's illegal. But the court's going to have to make up its mind what it believes. And what it believes then will be tested under the rules that have been created by the courts on the issue of whether things should be suppressed, whether it's because of a search, a seizure, an involuntary confession, whatever it may have been. And the defense attorney is the prime mover in these motions, obviously. The prosecution is not going to file them. They don't want their evidence suppressed. The defense attorney must do that. So unless the defense objects, it is assumed that law enforcement officials have behaved properly. That means that you could have a situation where you have ineffective assistance of counsel, and which is a violation of the Sixth Amendment right to counsel, if there was good evidence available to the defense attorney that this was illegally obtained evidence and they didn't do anything. That can happen every once in a while. People make a mistake. All right, the defense posture of the prosecution. The defensive posture of the prosecution. Best case, suppression motions mean extra work. Worst case, the case is lost. They don't like it, but again, and especially if you're in the drug world and you're a drug prosecutor, a big portion of your work is dealing with these suppression motions because that's the only way the defense can win them. So they almost always try. Trial judge are the decision makers. They're the key policy makers in applying and implementing the Supreme Court decisions, deciding, every situation is at least a little bit different than ones that have come before. And so the courts have to decide, is this, subject to this rule or that rule, or what rule we're going to apply. And they also have to judge police testimony. And sometimes police are the only people who have knowledge of what happened regarding whether it was a legal or illegal search. And that's a little scary. The client may never even been around when the police were doing something and doing a search and had no idea what they were doing. And so could not even help you. And then can you win under those circumstances? Yeah, you can if the police are first honest and they've done something wrong. But that's a scary position to be in. All right, so let's look at the law and controversy. What about the cost of the exclusionary rule? Let's compare to the lack of evidence and witness problems. Compared to the lack of evidence and witness problems, Mapp and Miranda are minor sources of case attrition, meaning there are a small amount of cases that will go away because of these problems of illegal searches or seizures or the failure to give Miranda warnings. And so motions to suppress tend to be rarely filed in most cases unless they're your drug cases. Because drug cases tend to be search warrant oriented and lots of search and seizure stuff going on, and so there's at least it's ripe to try them. And so they will tend to try them much more often there. But otherwise, if you take every single criminal case, it is rare. And why? Because the police are doing a pretty good job for the most part. And so there's not any issues to be litigated. And so let's think about this question we have here on this issue. If we're talking about courts, controversy, and reducing crime, should the exclusionary rule be abolished? In essence, we've had it for now at least the last almost 60 years. In every context you can think of, have police learned their lesson, so to speak, so that if a cop makes a mistake, okay, we may use some illegal evidence, but it is going to be good evidence. It's not going to be made up evidence. It's going to be good quality evidence. Why should we have the exclusionary rule if cops are pretty much doing what the courts want them to and what the Constitution requires of them? Could we have a sort of a presumption of good faith on the part of authors, and so that you'd have to prove that they were operating in bad faith, meaning that they did what they did and they knew it was illegal at the time before we use the exclusionary rule? If we did, we'd have a lot more cases that would be good cases, because whatever we lose by the exclusionary rule would not be lost, most likely. So if one admits that there are problems in its current application, what realistic alternatives might you decide to do if we were going to do away with this exclusionary rule? What would you do? As I said, If I was going to do away with it, I would say you only use it when the cops know they're doing something illegal and they do it anyway. Not when they, in an honest attempt, were trying their best to keep it legal. No, I'd say no. But it's up to you. What do you think? All right, that's it for Chapter 11. And again, if you have any questions or you have any issues with regard to the learning for Chapter 11, please feel free to email, call me, text me, or otherwise contact me, and I'd be more than glad to help.